8:19 at WBAP. Doug Bracken joins us right now, an attorney with Scheef and Stone. We'll get into this lawsuit that has been settled now between Fox News and Gretchen Carlson. $20 million is what the settlement is.
And
apparently a public apology. It did.
Quick.
And apparently she's going to get a public apology as well. Fox News is going to pay her $20 million, not Roger Ailes, but Roger Ailes will supposedly issue the public apology to Gretchen Carlson, the former NBC 5-anchor, former Miss Minnesota, who, by the way, when she was in the Miss America pageant, do you remember what her talent was? Anybody remember?
I'm going to go with recipes.
No.
No, I don't know.
Classical violinist.
No kidding.
Yeah, still is to this day. Yeah. Doug Bracken joins us right now. This thing happened quickly. Is this just a give-up sign of we're guilty here?
Well, I can't say that they're necessarily guilty. I don't know all the facts, but I can say that it is very quick, and it's a sizable settlement, so it appears that the company wanted to go ahead and get this behind them quickly.
There's several other women that have accused Roger Ailes of virtually the same thing, maybe not to the extent that Gretchen Carlson did. I mean, is this just the beginning, or does that $20 million sort of put all the others to rest?
I doubt if it puts all the others to rest necessarily. Again, I don't know the terms of the settlement in detail, but I would think that this only involves Gretchen Carlson and the others who may have claims. This may set a precedent for them. That's one reason employers don't necessarily want to settle. Often they want to fight, but this may be a different type of lawsuit.
Are there rules or laws on timelines? What if somebody 2 or 3 years from now going, I think I want to do this also, or is it like the Bill Cosby thing? I mean, are there timelines to lawsuits?
There are supposed to be timelines, yes. There are sometimes exceptions, but under the discrimination and harassment type statutes, generally an employee has to bring a claim within 300 days to the EEOC. And then, there's a timeline for when they can bring a lawsuit after that.
Have we seen precedent before in a sexual harassment case like this on a corporate level to the extent of $20 million?
I don't think so, really. There are some cases out there that have been sizable sexual harassment cases, but this is clearly the most public and the largest one we've seen lately.
Hey, by the way, do we know any details about what she alleged happened?
All we really know is whatever she alleged in her lawsuit, and it included really two types of harassment, hostile work environment and even what's known as quid pro quo, which is the concept that if you give me certain advancement in my employment, I'll give you sexual favors. And there's really no defense to that kind of claim.
The definition of sexual harassment, if I go out to the one of the girls I work with here, one of the ladies or women, and say, I'm not busy, you want to go to lunch? Even though I'm married, it would be just hey, I want to go to lunch with somebody. And they say no. I say, okay. If I do it again tomorrow, would that constitute sexual harassment?
Not necessarily. There's no bright line, though, and if you're going to leave it up to ultimately a jury to decide, what the jury has to decide is, was it severe and pervasive enough to be a hostile work environment? Mm-hmm. And unless there's some kind of quid pro quo harassment.
Yeah. All right.
Thank you for the insight there. Doug Bracken, he's with the law firm Scheef and Stone, kind enough to join us today.